Welcome to this presentation on the different categories associated with employment, your employment status, and how you fit into the hierarchy: employee, worker, self-employed. My name is Steve Norton. I'm a solicitor specialising in employment law, and I hope you find this presentation informative and useful. As part of this presentation, we'll look at the meaning of employment status in English and Welsh law. We'll look at the case law, categorisation, the analysis, etc., and some of the relevant legislation, and take it from there. Thank you. Three main categories are: you're either an employee, a worker, or what is known as genuinely self-employed. So we'll look at those three different categories and analyse each one. So in terms of employment status on this slide, set out here in a few boxes, basically an employee has full statutory rights, contract of employment, and his or her contract terms are set out in that contract. A worker would have partial statutory rights or protections, but not certain rights that an employee has, like to take a claim for unfair dismissal, which an employee does have. The lowest in the pecking order is self-employed, with very few employment rights, and all of these will be sort of analysed as we look at the cases. If we look at, first of all, at the rights as an employee has, you will be considered or classed as an employee if you have predominantly an actual contract of employment contract with your employer, which is you normally sign when you accept the job, and this tends to be regular work as opposed to irregular. You're employed to do the work personally, which we'll look at in more detail later, and you must do the work that's given to you within reason. As an employee, you have employment rights, including you have a right to a written statement of employment particulars, which outlines your job rights and responsibilities as a minimum, Section 1 of the Employment Rights Act 1996. It sets out sick, holiday and parental leave pay, and you're able to claim redundancy and unfair dismissal, currently at 2 years, but is likely to change under the new Employment Rights Act 2025 and onwards when it comes into force. What rights does the worker have? You usually have some form of a contract for services, to do work or provide a service for a payment or reward, which once again can be verbal or in writing. You need to be employed to do the work personally, have very little obligation to receive or do work. For example, a 0 hours contract where you're offered work on an as and when basis, but you should do the work that you've actually agreed to do. So what rights do you have? Rights to the national minimum wage, paid holiday, pay slips, protection against unlawful discrimination, protection against whistleblowing, and not being treated less favourably if you work part-time. We now on this slide come to the self-employed person, which in terms of employment rights and protections is the lowest in the pecking order. You're usually classed as a self-employed person if you're responsible for how and when you actually do the work. Often you're an owner of a company or a freelancer, contractor. You normally invoice for your pay, contracts to provide services for clients. In these instances, you're able to send so you've got the right of substitution to send someone to do the work for you if it's appropriate. You're able to work for more than one client. You're able to charge different fees, do not get paid holiday or sick pay. If you're self-employed, you have some basic employment rights, which includes health and safety, protection of client premises, protection against discrimination, contractors and freelancers. If you're self-employed, you get work through an agency, you might be given a contract for services and be called a contractor. More detail on the ACAS website for that. Over the years, through mainly case decisions, different factual circumstances, certain principles have been established which are used to determine employment status, where they fall into those three main categories. These are level of control, how much say does the employer have over the individual? Do they dictate when and how the work must be done? Mutuality of obligations, is there a duty to offer work and for the individual to actually need to carry it out? In terms of personal service, can someone else step in if they can't do the work, which is basically substitution? Integration, arguments around if you're integrated into the organisation itself, maybe you're more likely to be a worker or an employee. Financial risks, is there a risk for the individual to lose money if anything goes wrong? Maybe more likely to be self-employed then rather than the employer as an employee and employer relationship where the employer takes a risk. Equipment, does the employer provide them with equipment, or you provide your own equipment? And this will determine if you're where you fall into one of the three categories. Remuneration, how will you be remunerated? Do you receive a weekly or a monthly wage? How do you get paid? Taxation could be a factor as well. If you're responsible for your own income tax, national insurance, contributions on earnings, you're likely to be self-employed, whereas if your employer is responsible for your pay and earnings and PAYE, etc., then you're more likely to be an employee, possibly a worker. This slide just looks into a little bit more detail the distinctions between employer and worker, and lastly self-employed, and how the Employment Rights Act 96 section 230 offers some assistance in the definitions. An interesting case on determining whether somebody is a worker or genuinely self-employed is the case of the Independent Workers Union of Great Britain versus Room Food Limited, trading as Deliveroo in 2017. Basically, they wanted the union took the case on their behalf on the basis that they were workers rather than self-employed, in order for them to participate in collective bargaining with the employer. This was taken to the Central Arbitration Committee, the sort of quasi-legal body as such, arguing this fact. Basically, though, the CAC found that they were not workers, as they had a right to substitute work with each other. They were to sort of do each other's work. It wasn't done personally for another party, so they didn't have that crucial element of personal service to enable them to be categorised as workers, so they were seen as self-employed and didn't have a right to collective bargaining. This was upheld, I believe, by the Court of Appeal and then Supreme Court 2023. Here in the slide we see key tests set out that were established through case law, which we analysed and looked into in more detail. But basically they are: is there a mutuality of obligation? Is there a contract to work personally? And to what extent is there a right to control how and when the work is done? And are the other contractual terms, either whether they're written or orally, consistent with an employment relationship? The area of mutuality of obligation it's a bit like mutual obligations in any contract on either side of the contractual agreement. There must be an employment contract, mutuality of obligation for a person to be a worker or employee. There will be mutuality of obligation if there is a legal obligation on someone to carry out some work in return for some, usually money or payment. There's no contract without mutuality of obligation. A volunteer is not an employer or a worker. There's some case references there, which include interns who can't be employers or workers. There may be some changes at some point to that situation at the moment. The obligation is only to do some work. Having a right to refuse or withhold work does not mean that there's no mutuality obligation, as long as there is some obligation to work and some obligation to provide pay for that work. There's a case there where a contract gives someone complete freedom to decide to refuse work, but however, there will be no mutuality of obligation as soon as they accept each new assignment or shift under a contract that lasts for the length of that assignment or shift. There's a case there. Another key area determining employment status concerns personal service. For both employee and workers, status to carry out the work personally. Someone who's generally free to provide a replacement or substitution, as in the Deliveroo case that we've just mentioned earlier slide, will be self-employed rather than a worker or employee, as long as the contractual right is genuine and unrestricted. And it doesn't matter if it's not used or not, basically. Some cases there, auto claims, got a famous one in real life. Time Civil Engineering Limited in Callahan, 2006. The EAT held that a lorry driver was not an employee because he had signed a contract previously that said that he could send a substitute, even though he never tried to do this. Where a contract allows for a substitute to be arranged only with the employer's approval, this is a restricted right to send a replacement and has been decided in these circumstances an individual can still be a worker. There's a case there, Byrne Brothers. McFarland and Glasgow City Council, 2001. Gym instructors were allowed by the council to send replacement instructors when unable to take a class. They owed an obligation to perform work personally, so were workers. This was decided at the EAT. Quite a well-known case was Pimlico Plumbers. Basically, a plumbing operative had no contractual right to send a substitute, but his employer allowed a practice of operatives swapping jobs around internally, which the EAT decided was a method of work distribution similar to shift swapping. It did not mean the plumbers were not under an obligation to provide work personally, so they were still seen as workers. Mr. Smith was expected to carry out the plumbing duties himself, and he was not allowed or authorised to send another plumber to carry out the duties on his behalf. So whilst Pimlico could use any plumber they wished to call upon, if Mr. Smith agreed to carry out work for them, he was agreeing that only he would do the work, so he could not send someone else. So that's a useful one in the self-employed versus worker status, because he was seen as a worker in this instance. This slide discusses the degree of control. A mutuality of obligation and an obligation to carry out work personally are core requirements of both employee and worker status. But the deciding factor in working out whether somebody is an employee or worker is a degree of control exercised over how and when the tasks are performed. So in an employment relationship, an employer is likely to have the right to control such things as the number of working hours, holidays, supervise, the way the work's done, work carried out, discipline, freedom to work for others. That usually comes in terms of the employment contract, if it's an employee status. Each case will be different based on the employment situation context. Control does not mean day-to-day control, but that the employer has the contractual rights to control the employee whether or not it is exercised. The rights it is exercised as such. There's a case there. Once again, we've got Pimlico plumbers looking at this time at the element of control. A plumber was ruled by the EAT to be worker not self-employed. The EAT found PPL choreographed its contract documentation to represent its workforce as self-employed, at the same time holding out customers that they were direct employees, giving that impression. The operatives were required to take all the financial risk. Their contract terms were non-negotiable. They took contractual responsibility for the quality of their work and paid their own insurance to cover risk of claims. Paid for their own equipment and materials, and paid their own tax and insurance. At the same time, they were tightly regulated, with their hours being controlled. They had to wear company uniforms with a company logo, only use branded vehicles and company mobiles. Deductions were made from wages at source, and operatives banned from giving out their own mobile number or working for private customers, with the sanction of instant dismissal. And also, operatives were not allowed to send a substitute. And the EAT ruled, Employment Appeals Tribunal, ruled that they were fully integrated into PPL's organisation in a subordinate and dependent position, and were to be categorised as a worker and entitled to the national minimum wage and holiday pay as a worker is. Now we move to the final category, which is self-employment. Now, the genuinely self-employed are not workers or employees, and as we've spotted earlier, only have very few employment rights. They're not entitled to national minimum wage, sick pay, or holiday pay. They must supply their own tools and equipment and are responsible for their own tax and national insurance. Self-employed workers, for want of a better term, are only entitled to the basic state pension provided they have sufficient national insurance contributions for at least 30 years. To be genuinely self-employed, you should genuinely, so to use that word again, be doing business on your own account and provide services to your own clients and customers. Now, for a key, well-established case that puts a lot of these factors together is for the requirements of contractor employment is the case of Ready Mix Concrete South East Limited versus the Minister of Pensions and National Insurance in 1968. So for a contractor employment to arise, there must at least exist an obligation to personally perform the work, as we've seen, mutuality of obligations, as we've also seen, between the employer and employee, and a sufficient element of control, which we've looked at, over the employee's work. So the facts of this case are: Ready Mix Concrete, RMC, was in the business of selling and delivering concrete. Previously, they had hired a haulage contractor to deliver the concrete to the customers, but had terminated his contract. They created a system of contracting with individuals as owner-drivers, some of whom had previously worked directly for RMC, including Mr. Latimer. His contract bound him to purchase a delivery truck from the specified company under specified terms and make this vehicle available to RMC at all times, 52 weeks a year, for the efficient delivery of ready-mix concrete within range of his base depot. When RMC applied to the UK government for a ruling on status for PAYE purposes, Mr. Latimer was declared to be an employee. RMC appealed to the High Court Queen's Bench, and the judgment was by McKenna J, who reversed the original decision, that held that Mr. Latimer was in fact a small businessman, and concluded that the contract was not of service but of carriage, as they used to call it. Test for the contract of service: did the worker provide personal service in return for remuneration? Is the worker subject to right of control in sufficient degree or to make the other master? Are the other provisions of the contract consistent with a contract of service? Looking again at another key case on employment status is Dillon and Dillon versus HMRC 2017. The Dillon and Dillon versus HMRC 2017 rather, the First Tier Tax Tribunal (FTT) held that a checklist approach could not be taken to indicate employment status. It stressed the need to step back and assess the whole picture when making an informed and considered opinion. The appellant provided haulage services, engaging drivers who, listed here, were paid a fixed amount per shift, could refuse jobs, were not guaranteed work, received induction training, had a limited right of substitution, and used the appellant's lorries. However, the drivers did not have any subsequent supervision and generally provided their own equipment. The FTT found that the drivers were employees during each individual contract. Key factors were the considerable degree of control exercised and the fact drivers were not in business on their own account. So it's made a comment at the bottom here. FTT assessed the employment status under tax legislation, which does not allow for additional category of workers. Whilst there are some key indicators as to the individual's employment status, this case does help highlight the fact that there are other factors which the courts and tribunals must also consider, i.e. the multifaceted tests which the employment tribunals have developed over the years. Another key case in this difficult distinction between different employment categories was Aslam and Farah versus Uber 2016. The Court of Appeal upheld an earlier decision that Uber drivers were workers. They were working when the app was actually switched on, and they were ready and willing to accept trips. Uber drivers were not employees as such, so because they didn't have the mutuality of obligations, they had no rights to any unfair dismissal claims, but were workers, so they'd be entitled to national minimum wage, holidays, working time directive, discrimination rights. And drivers' hours start when WTR, when she turns on their phone app to take their first customer. Drivers are now, following this decision, entitled to rest breaks along with holiday pay. Another case of note is Addison Lee Limited versus Mr. M. Lange and others at the Employment Appeals Tribunal 2018, where once again this was a case where a group of individuals were successful in showing that they were workers and not self-employed contractors, and therefore receiving national minimum wage and holiday pay. And more details on the slide here. That's useful to read in your own time. In another key case of Chatfield, Robertson, Phillips and Universal Arts Limited, 2018, UK Employment Appeals Tribunal, the AT found that an individual's right to use a substitute did not necessarily prevent the claimant from being an employee, and found that she was entitled to employment rights. This is an interesting case. Community-Based Care Health Limited versus Marianne 2018. a GP providing services to an NHS provider through a limited company was a worker under the Employment Rights Act 1996. Mr. Narayan, GP, was registered with Community-Based Care Health Limited, a company providing out-of-hours services to the NHS. Dr. Narayan had been providing services to CBCH since 2005 alongside doing locum GP work for an agency. Now, in October 2015, on the advice of her accountant, Dr. Narayan set up a limited company, RNJ Medical Services, which received payment from CBCH and from the locum work she carried out. Dr. Narayan did not tell CBCH that she'd set up the company, and instead simply provided the bank details of the company's account. In November 2016, CBCH informed Dr. Narayan that they were going to stop offering her work after issues arose over telephone advice that she had given and alleged shift swapping. She subsequently brought claims for unfair dismissal, race and sex discrimination, wrongful discrimination dismissal, and unpaid holiday pay in the Employment Tribunal. This goes on to the next slide. So just to follow on the Narayan case as such, the decision of the Employment Tribunal was in determining Dr. Narayan's employment status. The judge considered that some of the key features were that she actually provided her own medical equipment, she did not need permission to undertake other work outside CBCH services, she was not required to wear a uniform, she had worked shifts for CBCH over many years, both parties were free not to offer work or accept work from one another, and she had her own professional indemnity insurance. So the judge weighed up all of these factors, included that Dr. Narayan was a worker. Her claim for unfair and wrongful dismissal failed as she was not an employee, but she could pursue her claims for unpaid holiday pay and discrimination. On this one, CBCH appealed the decision and asserted that Dr. Narayan was self-employed. So what was the next decision? So the Employment Appeal Tribunal came to the conclusion that CBCH's first ground of appeal centred on the argument that he had a contractual relationship with the company, not Dr. Narayan herself, and that Dr. Narayan could no longer be considered a worker after the company became the contracting party. The argument did not succeed as it was not relied on in the first instance, but the EAT confirmed it was bound to fail in any event. Firstly, there was no requirement that the individuals perform the out-of-hours service were qualified and approved in order to meet the strict performance requirements set out by CBCH and the NHS. The EAT found that the company could not satisfy these requirements, noting that it could not treat a patient or prescribe a drug or exercise medical judgment. Secondly, it found the CBCH would not have been able to approve the company without knowing that it existed. The second ground of appeal was that the judge in the tribunal should have considered the case of Salhal and Hearts Urgent Care 2011, where a GP was found to be self-employed. The EAT actually distinguished this case on the basis that the GP in Salhal was found to be marketing his services to whichever provider or medical services that might want to provide him with work, whereas Dr. Narayan had worked shifts for CBCH over many years. The third ground of appeal was that the judge wrongly concluded that Dr. Narayan was an integral part of CBHC's operations. The EAT disagreed, finding that the issue was one of fact for the tribunal, and there was plenty of evidence that Dr. Narayan was in fact integrated into CBCH. So ultimately, the EAT dismissed the appeal and agreed with the Employment Tribunal that Dr. Narayan was in fact a worker. Other areas of difficulty where the court may have to really look behind specific facts and scenarios are categories such as agency workers. Sometimes an agency worker can be employed by an agency, but sometimes they're not. So there's an issue whether they have some sort of employment status or employment arrangement with the employer. They have some certain rights under agency worker regulations, etc. But that's a whole different area. Casual workers usually just paid for hours of work they do, so they're unlikely to meet any sort of mutuality of obligations with employees, workers, etc. 0 hours contracts are another area where there's a lot of changing legislation on that one. There's one to look out for in terms of the Employment Rights Act 2025, and there may be some changes to the status of people on 0 hours contract, that you'd have to find some sort of umbrella contract in order to establish what sort of status they have. Employment Rights Bill currently going through Parliament, 2025, likely to first part of it to come into law by the end of this year, and then over the following 2 years the other more complicated parts that require more detailed regulations will come in slowly. But in terms of employment status, although it was mooted early on that there would be some sort of discussion and looking into a single worker status, looks like that is going to be very complicated and difficult. So that's been put back some time. So that doesn't look like it's going to come into effect anytime soon. So we're stuck with the same structure in terms of employment, categories of employment as such, employment status. Finally, I hope you found that presentation useful and food for thought anyway, and informative. And please let me know if you found it useful basically for your purposes. Thank you. Bye bye.